If I was to say that 75,000 women were forced out of their jobs only in one industry in the state, what would you say about that? You may find it surprising to know that the one forcing the women out of employment over the last 14 years wasn't some industry but Maharashtra government itself. These women, who are dancers and waitresses working in Maharashtra's dance bars, faced up to 50% loss of income, and in some cases they were also pushed into prostitution, because first in 2005 the government banned all dance bars. That was then overturned by the high courts, but the government still brought in such regulation in the form of the Maharashtra Prohibition of Obscene Dance in Hotels, Restaurants and Bar Rooms and Protection of Dignity of Women Act of 2016 that not a single dance bar license was given. For example, one provision was that you can't have a liquor bar where a dancing area is, which the court held was totally arbitrary. The court said there was little or no material on the basis of which the state could have concluded that dance in the prohibited establishment was likely to deprave or injure the public morality or morals. If a discotheque or an orchestra is also on the same place where there is a dance bar, we find, they said, this to be a valid justification. The impugned provision, in our view, is totally arbitrary and irrational and has no nexus with the so-called purpose sought to be achieved. And therefore, the court said it was unconstitutional, this provision, and struck it down. Over the next half hour, we're going to speak to bar dancers association members. We're going to speak to the lawyer for the Maharashtra government. We are also going to speak to prominent lawyers and dance bar owners themselves to find out what has been the impact of this and why is it that something like this was brought in the first place. So joining us now, we have very well-known women's rights lawyer Flavia Agnes joining us from Mumbai. We also have joining us the Maharashtra government lawyer Nishant Katneshwarkar. We'll be going across to a dance bar owner in just a short while. But first, I want to go across to Nishant Katneshwarkar, who is the Maharashtra government lawyer. Now, if we go through some of the provisions and some of the provisions and clauses of this law, what the Supreme Court has done is some of the court has upheld. For example, what the government clause had said is that these bars can only operate from 6 p.m. to 11:30 p.m. Whereas the bar association owners were saying that, look, other establishments are open till 12:30 at night. Why is there a difference? Well, that has been upheld. That provision and clause still has been upheld because of the fact that they're saying that that's a completely different, and they can still operate if they have that level of operation till 11:30. But some other provisions, like they can't be given tips, like you can't have the dancing area and the bar in the same place, all of that has been struck down. So I wanted to ask the Maharashtra government lawyer that if we look at some of what has been argued and the state of the women who were impacted by all of this, it really makes me ask as a citizen, what was the point of all this? Because it looks like the Maharashtra government brought this in saying that they are trying to protect these women. But what it ended up doing was really causing a lot of damage. 75,000 women impacted. Does the government realize what a mistake they made?
See, earlier when there was total prohibition of dance bars, the provision was struck down by the Supreme Court as well as the High Court. Subsequently, to regulate the activities, because the state of Maharashtra wanted to follow the judgment of the Supreme Court in its letter and spirit, that's why this 2016 enactment was passed. That was also challenged by the bar owners in the Supreme Court. Today the Supreme Court has given a mixed judgment. It's a relief for the state of Maharashtra as well as bar owners as well as the bar girls also. I would like to emphasize on 2-3 aspects. First of all, obscenity aspect has been upheld by the Supreme Court.
Yes.
Then there will be no showering of money. There will be time frame specified by the Act, which is maintained 6 p.m. to 11:30. And most important is that there should be contract of employment between the bar owners and the girls. So their interest has also been protected. So when the act is upheld by the Supreme Court, I suppose it's a big relief for the state of Maharashtra and the people at large who were associated with this industry.
But Mr. Katneshwarkar, I'm sorry, your name is it's quite a tongue twister. I want to ask you, when you look at what the court upheld, that 85% of performers were migrants seeking better opportunities, 42% of women dancers were illiterate, 72% were sole breadwinners of the family. Look at this figure. 72% were sole breadwinners of their family who the Maharashtra government denied for 14 years. I know you went into all these aspects and you said that the court upheld various things, but does Maharashtra government, will you now provide compensation to these women who have been denied employment or driven to prostitution because of these bars being shut down?
The answer can be twofold. First aspect is why this was happening. See, earlier also the conditions were to be complied by the bar owners, but the bar owners wanted that there should be no conditions at all. So nobody came forward, nobody complied with the conditions, and still they wanted that their dance bars should be open. This is one aspect.
No,
That's
sir.
why on their own accord.
No, sir, I asked you a very simple question.
Account,
no, sir, I asked you a very simple question.
Yes, about
the courts
compensation.
have been very clear,
About compensation
whether
also.
it's the High Court or the Supreme Court, they've been very clear from the beginning that you can't shut down these bars. And yet the government did just that you shut down or you denied them licenses to operate.
No,
Who is responsible, sir? Does the Maharashtra government take responsibility?
See, there is no question of taking responsibility, because even in 2016 Act, certain conditions were prescribed. Court said to bar owners that you apply to the licensing authorities. Accordingly, more than 60 applications were received by the licensing authority, but none of them was complying with the conditions, such as fire NOC or other conditions. That's why not a single permission was given to run the dance bar.
Okay.
And
okay.
as on date, when if the applicants comply with the conditions as upheld by the Supreme Court, those bar owners only will be able to run the dance bars.
Okay,
so
Mr. Katneshwarkar
because of the arbitrary action.
Mr. Katneshwarkar, you're obviously not answering my question, and I just want to point out to our viewers as well that you're talking about provisions like fire licenses and all, but I read the 100-page judgment. The fight seemed to be about whether it's obscene or not, whether money should be showered or not, and what I was asking you is that the court is very clear that dance bars should not be shut down, and that's effectively what the court did. Flavia Agnes, if I can come to you. There are various aspects.
That is accepted. That is accepted.
You accept that. Yeah. Okay, Flavia Agnes, I want to come to you and look at this judgment that has come out over here. What would you call this? Would you call this the Supreme Court standing up for the right of women to work and any work of their choice without taking a moral stand?
I would think so, definitely. My whole grievance with the Supreme Court is the time frame it has taken. This issue has been going on in 2004, 2005, 2006, and each time it has been a contestation between the courts and the government, Maharashtra government. Every time, firstly the High Court upheld the right of the girls to dance. They brought in an amendment and they brought in a law which prevented the girls from dancing. It was challenged. It went to Supreme Court. In Supreme Court again it was upheld. Further then, after that, they brought in another rules and regulations making it almost impossible for bar owners to open up the bars to get a license. Again Supreme Court said this is arbitrary, this is violative. Nobody got any license. Now in the meantime, it's not just a question of compensation. These girls' dancing age is very limited, from say age of 16 to age of 30. Beyond that, it is not possible for them to dance. Now 14 years have gone. 30-year-old girls have become, women have become 45-year-old. Now, what are they going to get? Even if the compensation is there for any loss, today they are not in a position to earn a livelihood through dancing. For 15 years, what did they do? What did they show morality here? If somebody cannot earn money by dancing, and that's the only thing she knows, they are illiterate, they don't know anything else, they will go to prostitution. So where was the morality protected? Where was the morality of the entire state of women was protected? I do not understand. But issue is that the girls, the women did not go to prostitution. They had children who were studying in school. They were children studying in English medium schools. They were studying in hostels. All their money that they earned, they spent on their children's education so that the next generation could improve. Today what happened after the ban, the children were pulled out and they were put into prostitution. Young children of 12 to 14.
Yes.
Who is responsible for this? Is the Maharashtra government taking any responsibility for this? For the spoiling the future of these young girls, and where the breadwinner of the family is unable to earn, so these young children have to earn and to support the family. Is there no consciousness with the government? Whose morality are they trying to protect? Whose reputation are they trying to protect? I mean, what is this? Just because they are migrant, many of them do not have voting rights. As a constituency, they didn't matter as far as this government goes. And together, whether it's Congress, whether it's BJP, whether it's Shiv Sena, all of them are owning dance bars. They were entertaining their cadre in the dance bars. And there, in the assembly, they took a moralistic stand and they passed the first act unanimously. There was nobody speaking for the bar dancers because they thought if they spoke for bar dancers, they would be deemed immoral. So the morality won and livelihood lost.
And not just that, they didn't just pass it, all of them pass it. First, it was the NCP Congress which brought in such a thing to bar it, and then it was the BJP government. 2016. So both of them are equally liable. And to add to all the condition of women, which you pointed out, Flavia Agnes, I just want to add another kind of figure, which is very, very, and this figures, they are courtesy the NDTV University, which actually did a study on it. And they point out that 88% of these women, and remember the figure, 75,000 women, this is what's there in the petition as well in the Supreme Court, 75,000 women were affected and they chose this was their choice of work, and then people came and said you can't do it, and they stopped it. So 88% of them, as Flavia Agnes said, are between the age of very young, 19 to 30 years old. And now can they dance? What happens to all of them? And that's why we are talking about, that's the reality of this really. Now, let's just go in various provisions, because what's interesting is that certain things have been upheld by the Supreme Court. So dance bars are open, and when you look at the provisions over there, under what conditions will they operate? So we know already, we've dealt with the fact that dance bars will only stay open till 11:30, not beyond that, not like other establishments over there. Now the other thing which has been completely thrown out is that the government wanted to control the dance bars by saying that it has to be 1 kilometer away from a religious place, and also the entire dancing area had to be separate from where the drinking area was. The court said that doesn't sound like an okay thing at all. Now I wanted to ask Mr. Karneshwarkar, because this has been, today the court has thrown out these provisions, but what was the logic of it? Why is it that you wanted to do something? Because the court said in a place like Mumbai, which is so congested, you can't have a rule like that. So what was the logic of this?
Logic was that there should not be disturbance to these institutions. But if you see the judgment, the court has said that it is not possible to have a place within 1 kilometer of a religious institution or an educational institution. But the court has given liberty to the licensing authority to be reasonable about this area or the distance, and as per the judgment of the court, the licensing authority will apply its own mind, and thereafter permission will be given. This is with regard to the distance. Secondly, the court has definitely found that serving of liquor should be there. So this condition has been removed. One has to accept this position, and the order of the court will have to be followed in its letter and spirit. That is what I can say about these two conditions.
Okay, we are also joined by Prashanjit Keswani. He is the advocate for the dance bar owners, and Kunal Agarwal, who is the owner of Hotel Elora's dance bars. Mr. Agarwal, I realize, and perhaps there's been so much fear about ever since the 2005 law was brought in. Since then, we are told, and we tried to have some dancer on our show today to talk about what they've been through. And as you also said, as they also said, that they're too scared to come on camera. But I wanted you to be the voice of them, Mr. Agarwal. Can you tell us what has been the last 14 years been like for some of these women who work in your establishment?
Since 2005 onwards, the girls, they are suffering a lot. They are in a pathetic condition. The government did not rehabilitate these girls, which they had promised. The girls, in fact, the contention of the government was that there is prostitution in these bars. But in fact, we were saying this, that after the ban, there will be more prostitution. We do not have any prostitution. We do not indulge into such acts and activities. But these girls, after 2005, there were 75,000 bar girls who were working in the bars. They were working legitimately and in a dignified manner. But after 2005, we do not know the whereabouts of these girls, because as we understand that these girls, they went to Far East, they went to Gulf countries, and they were trafficked in those countries, and many of the girls, they did not return back from those countries. So, in fact, the prostitution contention that was levied by the government increased after 2005. The girls, they were in a very pathetic condition. They removed their children from the educational institutions where their children were studying. The girls, they had to sell off their houses. They were on a rented house, so they had to move to their hometowns, where
but
they
sir, your
fell
bar
sick.
is
Many
operating.
of them, they fell sick, and they did not have the money to. Sorry?
Your bar is, at the moment, your bar is operating. I mean, a lot of the women went, but after the courts overturned the ban, your bar is operational?
See, the dance performances were banned in 2005, not the bars. Bars are still operating, but the girls did not find any work in the bars because there was a restriction on the artist. There could be only 4 artists after 9:30. So the number of the girls, they reduced down. So only those who could sing were able to perform and earn their livelihoods.
So now what do you expect to change? How soon? I mean, do you go back to the pre-2005 days?
Well, in the first and foremost, I feel that the government, they should believe in the topmost court of the country, and every now and then, rather than filing review petitions and harassing these girls and debarring them from their livelihood, they should consider the Supreme Court's orders, and they should make the licensing act convenient for all the bar owners. They should allow them to operate, and once this happens, the girls, they will definitely come back to the forefold, and they will want to earn their livelihoods through the means that they were doing previously in 2005.
Mr. Keswani, if I can ask you, one interesting point is, which of course the Maharashtra Government Council was pointing out, is that the Supreme Court has upheld what the government had said, their clause about obscenity, and saying that there is that you all had said it's vague, that the definition of what's obscene is vague, but the court said no, it's not vague. Is that problematic for bar dancers now?
No,
yeah,
I don't
it's going
think
to be problematic
because
the interpretation of obscenity
that the dances
is not
that
clear.
happen in these
It
establishments,
depends upon how you interpret
so I was saying that
obscenity.
the dances that are
I asked
happening
Mr.
in these
Keswani.
establishments.
Yeah. Go ahead, Mr. Keswani.
Yeah. So what I was responding
something might
is
be
that
obscene for you and
right
may
from
not be obscene for me.
2005, when the first ban happened, our contention.
Go ahead.
No, exactly. Yeah. So therefore, our contention throughout has been that in fact the dances that happen in these establishments are not obscene. So therefore, in fact, the Supreme Court has clearly held this time that this is misplaced morality. There's nothing more, immoral about these dances. There's nothing obscene about it. In fact, the judgment is categorical on that. That this is misplaced morality. And now, in fact, the Supreme Court finally has said now the government must consider this with an open mind.
Okay, but sir, the one of the problems that you were pointing out is that the State Act punishes people for up to 3 years, but the Central IPC Act only for 3 months. But the court said no, those are different things. Isn't that a setback? So they still, if somebody is punished with this, they still face 3 years imprisonment.
That is something which we obviously have Supreme Court has really said it's a different type of an offence. So therefore, our contention on this hasn't been accepted. But like I said, from throughout our stand has been there is no obscenity in these establishments. It's just girls dancing where alcohol is served. So therefore, I don't see if, as per the letter and spirit of the earlier Supreme Court judgment and this judgment, if we are given licenses and allowed to operate, this aspect would create any problems, because we are in effect saying there is no obscenity in these dances.
Okay, it's Flavia, what would you read into this? Because what's also interesting is that the court seems to be towing a line. For example, all of us, our experience, for a lot of us, our experience of dance bars is what we've seen in the movies. And in the movies, what they show is, you know, that while the women are dancing, that money is showered on them. It's interesting what the court order says on that. They said it's, while the government had said it can be added to the bill, you can't throw money. The court also agrees that you can't throw women because they say that's not dignified.
Correct.
However, what's interesting is, Flavia Agnes, what do you make of this kind of,
Yeah,
you know, Flavia Agnes, I wanted her to answer that. What do you make of the stand that the court has taken? Do you think it's trying to toe some, you know, balance it all? It talks about the fact that you can be obscene. It says that you have to finish by 11:30. It says that you can't throw money at the women. You have to give tips in a separate place. What do you make of all of this?
Yeah, this had come even before that you can't throw money.
Clarify on that.
You have
the court
to
says
have
you can tip those
a
girls.
separate envelope or somewhere. But now issue is that firstly, what is obscenity? Now, if a dance in a film has passed censors and it is showing in public places and the girls are imitating that dance in a dance bar, how can that be obscene? They are wearing the similar kind of clothes, they are having the similar kind of step. What we see, what the public sees in the theatre is not obscene. Then what you see in a dance bar, the same dance, how can it be obscene? As Mr. Kunal Agarwal said, obscenity, and in the earlier judgment, judges have clearly said obscenity is a concept which, what according to me is obscene may not be obscene according to you. The standards are very different. But according to me, if the censors have passed it, it is not obscene. Why would censors pass a dance which is obscene and make it available and public viewing? But the question is, there it is on celluloid, you watch it, it is not live. But how can that make a difference? Because there the dance was live and then it was filmed and then it was shown. Similarly, the girls are dancing here and the people are watching. So what is the difference? I think this point may not have been argued very forcefully, that what kind of dances the dancers are performing and what kind of clothes they are wearing while they are performing these dances. They imitate Hindi film songs, and if those songs are not obscene, there cannot be a question of obscenity here. Secondly, about throwing the money. Throwing the money is a culture.
Yeah.
It is the tamasha culture that has come in Maharashtra. When you have a performance on the street and there was a culture of throwing money, the same came into the bar dances. But what I do welcome is this contractual obligation by the bar owners towards the girls, because earlier girls were not paid anything. Not only that, from what they earned, they had to pay a commission to the bar owners. Now today there is an obligation on the bar owners to have a contractual agreement with the dancers and ensure that they earn a certain amount of money that can differ from bar to bar and performer to performer. But I think this is what we had suggested in 2005 on behalf of the dancers, that there should be a tri-party agreement between government should monitor, the bar owners must agree, and the bar dancers' rights must be protected. The bottom line is the girls have to be protected. They cannot be exploited in the bars, because bars owners are not saints. I agree. Government is the demon here, government is the monster here, but even the bar owners have not been given a fair deal to the girls. So it is important that this tripartite agreement should come together. Each bar must contract with each girl, and that contract has to be implemented, and if the contract is not implemented, the girl should have a legal remedy for that. There was no such remedy earlier, and so in a way this is a positive step.
It is a positive step, and of course we're totally out of time, but the fate of the 75,000 women, and hopefully they all find employment. The government, today the Supreme Court standing up for them and their right to employment of their choice. That's it on Reality Check. Thanks to all my guests. Thanks for watching.